For the plaintiff to be allowed a default judgment, there must have been proper service of summons, so that if the defendant can actually show that in fact they were not properly served with the court summons, they can make an application to court and the court will set aside that judgment in default, even under Order 36 of the Civil Procedure Rules. You will note that the procedure under Order 36 is by way of plaint, but the plaint under Order 36 it is different from the plaint under Order 6 and Order 7 of the Civil Procedure Rules. In fact, the contents of the plaint under Order 36 is provided in Order 36. It is unique because in that case, whereas the contents may look to be the same, number one, it must be written on summary procedure under Order 36 as the heading. And secondly, the said plaint must be supported with an affidavit. Secondly, in the previous discussion, I mentioned that in that plaint, you must mention that the defendant has no defense, because it is on that basis that the court actually grants the order in default. Now, a judgment in default can be granted by court according to different circumstances. Of course, the first one being this under Order 36, Rule 5. When you look at Order 33, Rule 11, it says that after the decree, the court may, if satisfied that the service of summons was not effective, or for any other good cause which shall be recorded, set aside the decree and, if necessary, stay or set aside execution and grant leave to the defendant to actually defend. I already mentioned the case of Caltex Oil versus Chove. I will not go back there. So under Order 9, Rule 6 of the Civil Procedure Rules, where the plaint is drawn claiming a liquidated demand and the defendant fails to file a defense, the court may, subject to Rule 5 of this order, pass judgment of any sum not exceeding the sum claimed in the plaint, together with interest at the rate specified. Now, Rule 5 thereof requires the plaintiff who desires the proceeding in default of the defendant's filing of a defense to file upon the record an affidavit of service. So it is important that when you file a claim for a liquidated demand, always file an affidavit of service, because that is what proves that the other person was properly served. Now, under Order 9, Rule 8 of the Civil Procedure Rules, where a plaint is drawn with a claim of pecuniary damages only, or for detention of goods with or without a claim of pecuniary damages, and the defendant fails, or all defendants, if there are more than one, they fail to file their defense, the plaintiff may, subject to Rule 5 of this order, apply for an interlocutory judgment against the defendant or defendants and set down the suit for assessment by the court for the value of the goods. Order 9, Rule 9 of the Civil Procedure Rules, where the plaint is drawn, as is mentioned in Rule 8 of this order, and there are several defendants of whom one or more files a defense and the other fails to file a defense on or before the day fixed in the summons, the court, subject to Rule 5 of this order, may assess the value of goods and damages, or either of them as the case may be, and as against the defendant or defendants who have not filed a defense at the same time as at the trial, as against the defendants or defendants may proceed to pass judgment in accordance with the assessment. So the whole point is that a default judgment is that judgment or decree which is passed where the defendant has not actually filed a defense. Setting aside an ex parte judgment, Order 9, Rule 5, where the judgment has been passed pursuant to any of the preceding rules of this order, and where judgment has been entered by the registrar, in cases under Order 50 of these rules, the court may set aside or vary judgment upon the terms as it may think fit. you will realize that under these rules, where there is a judgment passed in any of the rules that precede that order, and judgment has been passed under rules 6, 7, 8, and 9. Uh, these are the ones which are passed in default of filing a defense. Secondly, judgment passed under Order 50, specifically Rule 2. These are passed by the registrar. So when you look at Order 9, Rule 27, it says that in any case in which a decree is passed ex parte against the defendant, he or she may apply to court by which a decree was passed for an order to set it aside. And if he or she satisfies court that the summons were not duly served, or that he or she was prevented by any sufficient cause from appearing where the suit was called for hearing, the court shall make an order setting aside the decree against him or her, or upon such terms as to costs, payment into court, or otherwise as it thinks fit, and it shall appoint a day for proceeding with the suit, except that where the decree is of such a nature that it cannot be set aside as against the defendant only, it may set aside as against any of the defendants. So according to this rule, an ex parte decree should have been passed against the defendant, and secondly, the summons must have been duly summoned, or non-appearance where the suit was called for hearing was due to a sufficient cause. Sufficient cause means you have a genuine reason why you would actually not appear. Order 36, Rule 11, after a decree, the court may, if satisfied that service of summons was not effective, or for any other good cause, which shall be recorded, so the court must put it down in writing, shall set aside the decree, and if necessary, stay or set aside execution, and may give leave to the defendant to appear to the summons and to defend the suit, if it seems reasonable to the court to do so, and on such terms as the court thinks fit. So under this rule, the suit shall be filed, this rule applies where, of course, the suit is under Order 36, and secondly, the decree has already been passed, and thirdly, the service of summons may not have been effective, or there was another good cause. There is a common case, Rondamu versus Chamurabi, whereby counsel entered the wrong date in the diary, and as a result, on that day, the defendant did not appear. And the court actually excused the applicant on the basis that counsel had, the court would not blame him because of the mistake of counsel. So the courts are really apply reason, or they are reasonable when deciding on whether or not to set a default judgment. However, that does not mean that that should be abused, because where it can be established that in fact there was proper service of summons, but this person did not appear, then in that case the court may not set aside the decree. There are many cases, of course, to that effect. Please, you can look at the Uganda Law Information Institute to get some more information about those many cases which have been decided. For example, the case of Waweru versus Ndiga, it was held that a mistake by an advocate, a mistake of an advocate is a genuine reason. Ignorance of an unrepresented defendant, illness by a party. In other words, where a party can show that maybe at that time they were not feeling well, then the court. In other words, it's giving room for courts to apply reason where there is a genuine excuse by that person who actually failed to attend. So this is the takeaway that I want you to note. Number one, Order 36 applies where the plaintiff is claiming for a liquidated demand. A liquidated demand means they are claiming for money. Or another scenario, it could be on a check, a hundi, a promissory note. It could be breach of contract. The whole factor that does not really change under this procedure is that the defendant has no defense. There is a clear agreement, there is a clear breach of the terms of those agreements, and for that reason, this person now seeks to claim the money which the other person owes to them. Secondly, it is very important for you to note that for you to succeed under Order 36, summary procedure, the other person should have been properly served. Thirdly, the other person does not have an automatic right to defend themselves, but they can seek leave of court, and if they can convince court that they have a genuine reason why they would not, why they would like to defend themselves, then the court will actually allow them to proceed. You should also note that it is a good practice to always file your intended written statement of defense on the pleadings, although the courts are a bit liberal. The whole point is that if the person actually shows some reasonable ground that there is a fact which can actually be subjected to proof, then they can actually seek leave of court to appear and defend. A default judgment, which is passed under Order 36, can be set aside if there was no proper of service, or if there was negligence on the part of counsel, or if there was a reasonable excuse. For example, if the intended defendant was sick, or if they were in prison, or whichever other reason that may sound reasonable before court. At the end of the day, it's how those reasons are presented to the courts of law.